Hi, I'm experienced U.S. trademark attorney Morris Turek. Today, I'm going to talk to you about the supplemental register as it relates to U.S. trademark registration. The supplemental register is provided by the United States Patent and Trademark Office as a way to federally register certain types of U.S. trademarks. Although it doesn't offer all of the benefits and protections of the principal register, it's still a valuable tool that should be utilized under appropriate circumstances. The USPTO maintains two separate trademark registers. The principal register is reserved for trademarks that are considered distinctive. On the other hand, the supplemental register is for trademarks that have not yet acquired distinctiveness or secondary meaning in the minds of consumers. There are many types of trademarks that may only be eligible for registration on the supplemental register. I will refer to these types of trademarks as non-distinctive marks. The following are some very common examples of non-distinctive marks. Marks that are merely descriptive of the products or services with which they're used. Marks that are primarily geographically descriptive of the products or services with which they're used. Marks that are deceptively misdescriptive of the products or services with which they're used. And marks that are primarily merely surnames. Now let's say that your trademark happens to be a non-distinctive mark. Although your non-distinctive mark would typically be eligible for registration only on the supplemental register, you still may be able to register it on the principal register if you can prove to the satisfaction of the USPTO that your non-distinctive mark has in fact acquired distinctiveness in the minds of consumers. The good news is that if the use of your non-distinctive mark has been substantially exclusive and continuous for at least the previous 5 years, then there's an automatic presumption that your non-distinctive mark has acquired the requisite distinctiveness for registration on the principal register. I'd say that in about 80% of cases, the USPTO approves a non-distinctive mark for registration on the principal register if the 5 years of substantially exclusive and continuous use requirement has been met. But what if you've been using your non-distinctive mark for less than 5 years? Well, you have the option of presenting actual evidence to the examining attorney demonstrating that your non-distinctive mark has in fact acquired distinctiveness. Such evidence could include the following: sales figures, revenues, advertising expenditures, customer declarations, unsolicited media coverage, and market surveys. If the information, materials, and other data you provide convinces the examining attorney that your non-distinctive mark has acquired distinctiveness in the minds of consumers, then your mark will be approved for registration on the principal register. Conversely, if the examining attorney believes that your evidence is inadequate and unpersuasive, then registration on the supplemental register may be your only viable option. Once you have 5 years of substantially exclusive and continuous use of your non-distinctive mark, you may file a new trademark application to seek registration of your mark on the principal register. One important thing to keep in mind is that registration of a non-distinctive mark on the supplemental register requires that either 1, the mark be in use in commerce in the United States, or 2, the mark be eligible for registration under Section 44E of the Trademark Act. A trademark application filed under Section 1B, Intent to Use, cannot be amended to seek registration of the mark on the supplemental register until there's use of the mark in commerce and an acceptable amendment to alleged use is filed with the USPTO. Again, I'm experienced U.S. trademark attorney Morris Turek. If you have questions about the supplemental register or want to know whether your particular trademark might only be eligible for registration on the supplemental register, please don't hesitate to contact me for your free consultation. I look forward to hearing from you soon.